Hi, it's Shan Wu with an Undercolor of Law hot take on the disqualification of Fani Willis, the Fulton County District Attorney. So let's start actually with a MAGA scholar view on this and take a listen to Professor Jonathan Turley.
She was wrong to bring the case against Trump. There are some viable claims here. She charged some people with unlawful entry or access to restricted areas. Those are not particularly serious crimes, but they are crimes. She was wrong to go after Trump on this basis. She clearly wanted to engage in lawfare, and that's one of the reasons why she wouldn't give up the case. When this issue was first raised, many of us wrote at the time that the correct move is to remove yourself. You selected a former lover as the lead counsel. That violated, in my view, core ethical requirements. He was ultimately disqualified by the court.
Her conduct violated, he calls it, core ethical requirements. What are those? He describes as you being Fani Willis hired your ex-lover to be a prosecutor, and basically implies that there's some enormous breach of professional ethics there. Well, here's the problem with that. That's actually not even what the opinion says. So just to put it in context here, you may recall this issue was raised quite a while back, and that the presiding trial court judge, McAfee, held a hearing about it. And he ruled that there was a choice to be made. First, he said, you can't dismiss the case. There just isn't any prejudice here. There's not even any actual conflict of interest. And then he gave the district attorney's office a choice. Said either because of the appearance of impropriety, the district attorney's office can step aside, recuse, or Nathan Wade, who is the prosecutor who allegedly had the romantic relationship with Fani Willis, that Wade could step down. They chose to have Wade step down, and then Trump's and his co-defendants appealed the case. And so what's now happened is that the Court of Appeals in Georgia, not the Georgia Supreme Court, but the Intermediate Court of Appeals, took the highly unusual step of reversing the trial court judge here. And we'll talk about why this is so unusual and frankly without legal merit, and said, no, actually, we don't like what you did, trial court judge. We're saying that Fani Willis and her office have to be disqualified. Having Wade step down wasn't sufficient. So let's break down that decision a little bit, and you will see, of course, that it has very little to do with what Professor Turley is talking about. Now, what's really disturbing about this decision is it follows what I would say is a kind of a trend among conservative judges, that they no longer respect stare decisis. That's the doctrine of following previous judicial decisions. And maybe it's a trickle-down thing, right? The Supreme Court seems to be leading the way of being dismissive of precedent. Really interesting article from the American Bar Association. We'll put that up for you to take a look at. But in June of 2023, the High Court kind of went like on a crime spree, a precedent-flipping spree, if you will. In a matter of days, it overturned some 200 years worth of precedent, which of course included doing away with the near half century of protecting women's reproductive rights when they overturned Roe versus Wade. So whether it's a trickle-down effect from that, or whether it's just something about, conservative Republican jurists, they only seem to respect precedent or even lower court decisions if it coincides with what they're thinking. So in this instance, it's particularly meritless that the Court of Appeals overturned the trial court, Judge McAfee's decision, because he actually took the allegations quite seriously. If you recall what the allegations are, it's this kind of convoluted theory that because, let's assume D.A. Willis and Nathan Wade did have a relationship, they seem to have said they did have one. The convoluted part of it is it says that these two prosecutors, both prosecuting on the same side of the courtroom, that if they're involved in a relationship, it somehow prejudices the defendants. And the lawyers who brought this up, I'll say this without irony, was Trump attorney Ashley Merchant and her co-counsel, John Merchant, who was her husband. And so they're arguing, we're a husband and wife co-counsel team, but the other side, if they're dating, that's prejudicial to the case. I mean, it's ridiculous kind of hypocrisy going on there. And so the argument that they tried to derive from this is, oh, Willis and Wade have had dinner dates, they travel together, and since Wade's being paid, this creates a conflict of interest where it's in her favor because he's getting paid that he can spend money on going to dinner and vacations and such. It was pretty convoluted, but nevertheless, Judge McAfee wanted to take it very seriously, and he held really a circus of a hearing lasting some 4 days, in which he and the whole country took a deep dive into what the BBC termed to be Fani Willis' sex life, as well as Wade's divorce proceedings, their dinner dates, etc. And at the end of that, the judge reached the right decision, which he said there isn't any kind of conflict of interest here. I mean, there's no indication that the district attorney was benefiting financially from this. But nonetheless, he had to add in this kind of gratuitous comment, some of you may remember, where he said the whole proceeding still had the, quote, odor of mendacity. I mean, the odor that I smell was one of pretentiousness. And then he ruled that there was an appearance of impropriety, and that had to be remedied by either Wade or the office disqualifying. You might wonder, why does the whole office have to go? Bit of a legal technicality, which is the assistant district attorneys are really just serving as the stand-ins for the district attorney. They're like extensions or agents of the main DA. So if the main DA is disqualified, everybody under her has to go as well. So the appellate court decides to dismiss McAfee's decision on this point. And there's a complete lack of common sense. They take this appearance of impropriety so seriously that they want to get rid of District Attorney Willis altogether. Let's start with just the common sense problem with it, right? The illogic of it. As we were discussing before, two lawyers on the same side of the courtroom, they have a romantic relationship. You know, how does that actually give them an unfair advantage? They're not doing anything that they didn't used to do in terms of the case. Really, the whole complaint against Fani Willis here, a number of commentators, including me, have said this, it really reeks of a misogyny, right? It suggests that a woman cannot be trusted to be competent at her job if she has a romantic or sexual feelings towards a coworker. You know, can you imagine that if Fani Willis were a man, that the same complaint would have been made, that the man had gone out on dinner dates or, you know, had a girlfriend who was in the office, and that would somehow affect his professional judgment? It never happened. So while it is a legitimate human resources question, some places don't want coworkers dating, you have to disclose that. You certainly have a concern if it's a supervisor dating someone who's a subordinate, because there might be, you know, unequal power there that can turn into sexual harassment. But it is not a basis for the company itself being disqualified, right? Just take an analogy. Imagine you disqualify SpaceX or Microsoft from government contracts because their executives may have been dating fellow employees. That makes very little sense. And of course, you know, that instance has certainly happened, not just there, but in the Microsoft instance. We'll put up this piece that came out a while back about what had happened there in terms of dating. But despite finding no actual prejudice, trial court didn't find it, and appeals court concedes there's no actual prejudice, the appeals court still doesn't like the fact that Fani Willis is in the case. And they talk about the fact that the splitting the expenses for dinners and vacations, they refer to this as a, quote, reimbursement practice that's unusual. And they also talk about it's very worrisome there's a lack of documentation because there was no, quote, unquote, ledger. Now, I find that kind of interesting because most people aren't writing into a ledger when they go out on dinner dates. They really kind of seem to be invoking the spirit of John D. Rockefeller from the Gilded Age, the original Rockefeller who founded Standard Oil. He famously kept a small red notebook he bought at the age of 16 in which he every day religiously wrote down every single expense he did. He referred to it as Ledger A. And actually, Ledger A, which obviously became a lot more than one notebook, it's actually in the government archives now on microfiche because it's such an interesting historical artifact. But most people don't follow Rockefeller's lead when they're documenting their dinner date expenses. And it seems like a really poor basis upon which to disqualify an entire prosecutor's office. And actually, the dissent in the appellate opinion points out the nonsensical nature of this. We'll put up a quote from the dissenting opinion that reads, quote, "For at least the last 43 years, our appellate courts have held that an appearance of impropriety without an actual conflict of interest or actual impropriety provides no basis for the reversal of a trial court's denial of a motion to disqualify." Why does that make sense? The trial court's in the best position to judge this type of situation because it's extremely circumstance specific. They've got live testimony, they have an operational view of the prosecution, and that's why you want to make sure that you defer to the trial court. That's why the appellate standards actually quote an abuse of discretion. Very hard to overturn that. Nonetheless, this appellate court managed to overturn it because they said no other remedy besides getting rid of Willis will, quote, suffice to restore public confidence in the integrity of these proceedings. You know, you're probably wondering, like I am, how does the appeals court judge public confidence? You know, are they conducting polls? Are they, on Trump's Truth Social or Elon Musk's X or other social media trying to figure out, gee, what is the public opinion here? No, of course they're not doing that, right? They're not going to be judging that. What can they judge on then? Well, that's exactly why you follow precedent, because common law evolves through precedent over decades, sometimes hundreds of years worth of precedent, of judges looking at all kinds of different circumstances, deriving rules from that to follow it. That's what they didn't follow here. That's the common law. That's stare decisis. So we'll keep an eye on this. It's still going to be appealed probably to the Georgia Supreme Court. Obviously, enormous delay from this. They have to find a different prosecutor to take the case. So it's possible, this is really effectively the end of the road for the case. But we'll keep an eye on it for you, and we'll talk again soon. Thanks again for watching and listening. Keep those comments and replies coming, and do subscribe to our channel. Talk to you soon.
In collaboration with the Midas Touch Network, we just launched the Legal AF YouTube channel. Help us build this pro-democracy channel where I'll be curating the top stories at the intersection of law and politics. Go to YouTube now and free subscribe at Legal AF MTN. That's at Legal AF MTN.